I'd like to now introduce Judge Richard Stearns from the United States. He's our Chief Justice's delegate to this conference. Thank you, Judge Stearns.
At the outset, when I had my first opportunity to address this distinguished audience, the fundamental point I tried to make is that despite the diversity of the legal traditions from which we come, convergence is really the theme of this conference. Let me just stress very briefly what I've learned over the last 3 days that we agree upon. First, we agree that when we talk about the independence of the judicial power, as our previous speaker pointed out, we refer both to the independence of the judiciary as an entity and the independence of the judge as an actor in the judiciary. We all agree that by independence of the judiciary, we mean freedom from intrusion by other branches of government on the judicial function. We also agree that when we refer to the independence of the judge, we mean by that the insulation of the judge from extraneous influences on his or her decision-making. We all agree that accountability is a necessary component of judicial independence. We all recognize that the reason that we believe this is because accountability is essential to the preservation of the public support that allows us to remain independent. We also agree that there are certain aspects of accountability that are universal to our judicial systems. I'm going to mention them now, at least as I've learned them over the last 3 days, and I'll call them the 5 pillars of experience. We all agree that accountability first means transparency, that our proceedings in our court, with the rarest of exceptions, must be open to the public and to the press. The second pillar is ethical probity. This means the avoidance of appearances as well as actual conflicts of interest, the avoidance of favoritism, and neutrality in our treatment of those who appear to litigate before us. The third pillar is accessibility. The public must understand the work that we do. The public can only understand our work if we explain what we do in clear, written, and rational decisions that are published for the public to examine. The fourth pillar of accountability is efficiency. Litigants deserve to have their disputes resolved in a reasonable period of time and in a reasonable manner. And the final pillar of accountability is discipline. Mr. Afferson alluded to this in his opening remark. By discipline, we mean the ability to recognize and correct our own mistakes and to adapt ourselves to the changing needs of the public that we can serve. So this, I suggest, illustrates my point of convergence.